Legal malpractice and consent. When does the lawyer need consent from the client? And when does that arise to legal malpractice? How do you get to legal malpractice when there's a failure to consent to something? Good afternoon. My name is Neil Burns, and along with my partner, Roshan Jain, we've been asked to talk today about consent and how that factors into a legal malpractice case. The easiest example to use is consent to settle a case. And this happens all the time. When you have a case, you consent to, typically like in a personal injury case, you give your lawyer, you consent to getting your medical records. You sign a waiver form, and he or she gets your medical records, and they send them to the insurance company so you can try to settle the case. But the attorney needs to ask you if a settlement is fair, and you need to say yes. And it sounds pretty straightforward, and it's not usually a problem, but we have a lot of calls along these lines here. The lawyer settles a case, and it tends to be the TV lawyer who the paralegals there have metrics they have to meet every week. They have to bring in a certain number of cases, settle a couple of cases, certain number of cases, and send demands out on a certain number of cases, and they've got to meet those. So they get an offer of a certain amount of money. They negotiate for 5-10 minutes. They're looking at their watch. They got to go on to the next case. They're pushing. They're under a lot of pressure to meet their metrics. They settle the case, and they say, we'll take it. And sometimes the insurance company will send a check. Sometimes they'll sign your name. Sometimes they send an email to the wrong email address saying, if you have a problem, give me a call in the next 37 minutes. And of course, you don't get the email or you don't consent, or you're not in the country, so you can't possibly respond. In any event, you don't consent. And this leads to a lot of malpractice cases, a lot of misunderstandings. Sometimes it's in the middle of a jury trial. Sometimes it's during a mediation. But do know that if you do consent, and then you later on say you're under pressure, in a divorce agreement, it's not going to work because the judge asks you if you consent. In a mediation, it's probably not going to work either. You have a lot of people who are going to say, this guy appeared pretty rational and settled the case for way more than we all thought it was going to be worth. So you probably don't have a case there if you actually did consent. But if you did not consent, then you might have a much better chance of a case. But do remember, you still have to prove that you had a lawyer, that he or she was your lawyer, that they had a duty to work on such and such of a case, that they breached their duty by failing to get your consent, and that there were damages. If they consented to dismiss a case that was never going to get you a penny, even if they lied, they may be subject to disciplinary findings against them, but there's no damages if you were not going to win a penny. So it can be complicated. Call a lawyer with experience. Call us. We're aggressive. We're effective. We care about you, and we'll help you. And we'll get an expert, and we'll work on your case. It's a free initial consultation. Call Burns & Jain, 617-227-7423. Thank you.